Bail reform is a controversial topic that has sparked heated debates across the United States. While proponents of bail reform argue that cash bail is unfair, discriminatory, and costly, opponents claim that eliminating or reducing cash bail would have negative consequences for public safety, crime prevention, and victims' rights. In this section, we will discuss some of the potential drawbacks of bail reform, such as increased crime. Some critics of bail reform fear that releasing more defendants without requiring them to pay bail would lead to more crimes being committed by those who are out on pretrial release. For example, in New Jersey, a man murdered someone just days after his release under the state's reformed bail system. Similarly, in New York, some media outlets and politicians have blamed the recent spike in violent crimes on the new bail reform law that took effect in January 2020. However, it is important to note that there is no clear evidence linking bail reform to the rise in crime, and that many other factors, such as the pandemic and the economic downturn, may have contributed to the increase. Public safety risks. Another concern raised by opponents of bail reform is that releasing more defendants without assessing their potential dangerousness could pose a threat to public safety. They argue that some defendants may have a history of violence, mental illness, substance abuse, or gang affiliation, and that releasing them without supervision or monitoring could endanger the community or the victims. However, supporters of bail reform point out that public safety has not been a legal reason to set bail for a defendant in New York since 1971, and that judges can still impose other conditions of release, such as electronic monitoring, curfews, or drug testing, to ensure compliance and prevent harm. Unfairness to victims. A third argument against bail reform is that it would be unfair to the victims of crime, who may feel violated or traumatized by seeing their alleged perpetrators walk free without paying any price. They contend that cash bail serves as a form of accountability and deterrence for defendants, and that eliminating or reducing it would send a message that their crimes are not taken seriously by the justice system. However, advocates of bail reform counter that cash bail does not guarantee justice or restitution for victims, and that it may actually hinder the resolution of cases by creating incentives for defendants to plead guilty or accept unfavorable plea deals just to get out of jail. Bail reform is a contentious issue in Canada, as it involves balancing the rights of accused persons with the safety and security of the public. In this section, we will analyze how bail reform could violate the Charter of Rights and Freedoms, especially the right to a fair trial and the presumption of innocence. The Charter of Rights and Freedoms is the supreme law of Canada, and it guarantees certain fundamental rights and freedoms to all Canadians. Among these rights are the right to liberty, the right not to be denied reasonable bail without just cause, the right to be presumed innocent until proven guilty, and the right to a fair and public hearing by an independent and impartial tribunal. These rights are essential for ensuring that accused persons are treated fairly and humanely by the criminal justice system. However, some recent proposals for bail reform could potentially infringe on these rights. For example, Bill C-48, introduced by the federal government in May 2023, would make it harder for those accused of certain offenses to be released on bail. The bill would create a new reverse onus for serious violent offenses involving weapons, expand the use of reverse onus for firearm and intimate partner violence offenses, and allow courts to consider community safety and an accused history of violence when making a bail decision. A reverse onus means that the accused person has to show why they should be released on bail, instead of the prosecution having to prove that they should remain in custody. This shifts the burden of proof from the state to the individual, and could undermine the presumption of innocence. Moreover, a reverse onus could result in more people being detained before trial, which could violate their right to liberty and their right to a fair trial. Detention before trial can have negative impacts on an accused person's mental and physical health, their ability to prepare their defense, their employment and family situation, and their chances of being acquitted or receiving a lighter sentence. Another concern with bail reform is that it could disproportionately affect certain groups of people who are already overrepresented in the criminal justice system, such as Indigenous people, Black people, and other vulnerable groups. These groups may face more barriers to accessing bail, such as poverty, lack of social support, discrimination, or systemic racism. Bail reform could exacerbate these inequalities and further marginalize these groups. Therefore, bail reform could violate the Charter of Rights and Freedoms by infringing on the rights of accused persons to liberty, presumption of innocence, and fair trial. Bail reform should be done carefully and cautiously, with respect for the Charter and its principles. Bail reform should also be accompanied by other measures to address the root causes of crime and violence, such as investing in social services, mental health and addiction supports, housing, education, and employment opportunities.